Howdy, my name's Max with Hutchinson Construction. I'm the Logistics and Supply Manager here. Today we're going to be going over the Bomag BW284 Vibration Smooth Drum. It's another piece of equipment we use on every single one of our projects. We got to get it to get compaction in our moisture control. We got to get compaction in green spaces. There's a lot of different spots that we just have to get compaction in, and this is the best way of doing it. Its operating weight is 28,423 pounds, but with the centrifugal force of there's a motor inside this big drum that spins. With it spinning in medium level, it's actually putting 34,643 pounds down onto the ground, making it where we're going to pass our compaction tests in our MC pad. It holds 75 gallons of fuel. It's a 12-volt system, and it can go a maximum speed of 10.1 miles per hour. Highly advised not going that fast, all right? This thing will throw you off. This one has a cab. A lot of them don't have cabs, and there's usually a lot of big risk with these things rolling over. So you got to be careful getting on inclines or going next to holes or trenches, because you don't want to roll off and get somebody hurt and cause an incident. The vibration frequency, it has two different vibrations on it. It'll vibrate at a frequency of 59.7 hertz on frequency 1 or vibe 1, and then on vibe 2 it'll vibrate at 66.7 hertz. The drum width on this one is 84 inch. That's what we normally use. It's 84.1 if you want to be technical, and its diameter around is 54.1 inches. We use this a lot. I mean, it's a workhorse as well. You know, in the summer you got to have the cabs, but there's a lot of information online again on these things. But if you have any questions, just please let us know down in the comments. We'll be happy to answer them. Thank you and have a great day.
Well, welcome everybody to episode 7 of the Civil Matters podcast. Today we have Lee Banta, partner with Peckar and Abramson, that's joining us to talk about some legal matters and some current events. So welcome, Lee. Appreciate you coming on.
Thanks for inviting me.
Yeah, so to get started, could you share with us a little bit about, some of your early journey? Like, did you always know that you wanted to be an attorney?
No, definitely not. Kind of stumbled into that when I was wrapping up college, graduated in 2010. So the '08 crash had recently occurred. Everyone was fleeing to go to grad school and avoiding the job market. I ended up teaching for a few years just to try to figure out what I wanted to do with my life professionally. Realized teaching was fun, but wasn't my calling. So that's when I kind of applied to go to law schools. I was a history major, so there's only so many careers open to someone who was terrible at math but good at writing. So law school fit the bill.
So you were teaching at what level?
Taught freshman and sophomore history for high school.
Okay. And that was your original plan, was just to be a history teacher?
I'm not sure I've ever had a plan. Probably still don't have a plan professionally. It just kind of go from one thing to another. But my family has a history of educators, so it was something that you just kind of intuit, from family experience, and it's something you should try. And so I put my hand at it, and I think it was a good teacher. I'll have to ask my former students what their thoughts at it were, but respect for the profession, that servant's heart that you need to have as a true educator, and it just wasn't going to suit me long term. So that's when I kind of thought, let's try my hand at law school.
How long did you do that, the teaching?
Did that for 3 years.
Okay.
And honestly, there's a lot of transferable skill sets from being a teacher to being an attorney. You're taking complex issues, you got to distill them down to more digestible notions that especially a jury can appreciate. You're trying to quickly triage problems. Be a student who's got trouble learning, trying to figure something out. The client issues of how can we quickly get to the root problem, try to get through an impasse, find a resolution without everyone's spending too much money.
Are there any similarities with high school kids and some of your clients?
Yeah, I taught at it was a boarding school in Virginia, the last all-male, all-boarding, non-military boarding school in the country. So the way high school boys behave and the way that a lot of contractor clients behave are eerily similar. Same penchant for four-letter words, and a general suspicion of authority.
I guess I should clarify, you practice in construction law, right?
Exactly, yeah. Board certified construction law attorney in my firm. That's all we do is service the construction industry.
And are you from Texas?
No, I am from New Jersey originally, but as they say, the strong survive, but the smart leave the state.
And what brought you to Texas?
It was just when I was looking for law schools. I had no interest in staying up north. My wife was from Virginia, so I was just looking at the best bang for my buck for law schools, which kind of was southeast in Texas, and got a good scholarship opportunity at U of H Law that I took. And also figured that my wife would be able to find a job in Houston. So it kind of made sense for the team.
And have you always been with a firm?
No, I started first 2.5 years after graduating law school at a small commercial litigation firm that had a sort of strong subset of material men, subcontractors, and vendors. And so that kind of was where I cut my teeth on the construction stuff. Enjoyed those types of disputes, enjoyed the tangible nature of a construction dispute where there's a project or something real going on or something not going on, as the case may be. And so when I was looking to make a move, I thought that the construction industry would definitely be something fun. There's always disputes. I'm a litigator, not a transactional attorney. And it's certainly been rewarding because something goes wrong every different way on a project. So you really get to learn the industry in and out, each case at a time. With a different wrinkle always coming up.
So speaking of construction law, are there, and I hate to put you on the spot, are there any recent developments in Texas law that contractors should be aware of, even subcontractors or general contractors that you?
I think I see you have the executive orders flying out left, right, and center from the federal government. So that impacts a lot of public projects. The push to kind of end the minority and disadvantaged businesses preference, trying to make that more of a straight competitive bidding environment. Seen that be pushed forward federally, and that states specifically, and kind of the right-leaning states are following suit. Texas is a good example of that. We're now the only kind of extra support that companies can obtain on a bidding for a public job or veteran-owned businesses, but they're not doing the minority or women-owned businesses as they've supported in the past. So that's definitely going to change up on the public side. The legislature has been slowly trying to chip away over the years, trying to make a more fair playing field, specifically for subcontractors and vendors, cleaning up Texas lien law, which has got to be the most convoluted set of lien laws in the country. Make that a little bit more straightforward, so subcontractors aren't being prejudiced with these hyper-technical timing and notice requirements. And then there's also been recent legislation passed to protect contractors and subcontractors from getting CCD'd to death. That is kind of a cap now that if you have more than 10% of your original contract value in unapproved change directives that gives the contractor the opportunity to suspend work until you finally reach alignment on a approved change order.
That's helpful. And is it a myth that the pay when paid or pay if paid clauses, and there's something in Texas that makes it such that doesn't really apply, even because we see that in contracts all the time?
Yeah, so there's legislation out there that provides a vehicle for the downstream party that's subject to the contingent payment clause, which is a pay if paid provision, to challenge the ongoing enforceability of that. It is probably the worst worded statute in the construction industry. No one understands how it's supposed to play out. The general idea is that if you're, call it subject to a contingent payment clause and the GC hasn't paid a couple of your pay apps, you can submit a letter protesting the ongoing enforcement, and then there's a short clock, approximately 10 days, different timing requirements, by which the general contractor who's relying on the contingent payment clause to explain why it's enforceable. But the long and the short of it is that this legislation is supposed to protect an innocent sub from having to continually bankroll a project because of upstream cash flow issues that maybe the owner is having. So unless the GC can show that the basis for non-payment is because of that specific subcontractor's acts or omissions, then technically the contingent payment clause is not enforceable. But the thing that all practitioners in court struggle with is, does it only work while you're on the project? Say you're like 50% complete and you haven't been paid and you submit the protest letter, or does it work even after substantial completion and kind of nullify the contingent payment clause even after the project's over? It's just poorly written. There's been articles sort of talking about what probably should be the outcome, but it's a lot of uncertainty because it hasn't been something that the courts have issued a lot of clear guidance on, which is fodder for litigators to take both sides of the argument, but certainly it doesn't help the industry in having legal certainty of when or when not these provisions can and cannot be enforced.
Do you know if there's any legislation working on that, or are you forced to rely strictly upon precedent?
Yeah, that's one that won't be subject to any sort of legislative efforts in the near term. So you really just kind of see what happens in the court system if certain cases kind of work their way up through a trial and then through an appeal, to see what kind of opinions are being issued by the appellate courts or Texas Supreme Court that would give further guidance on how that statute plays out. I think the big push recently in the legislature from the construction industry is also trying to provide protections on the clarity of the independent contractor status. See, federally, especially if it's more Democrat-controlled government at the time, they really are trying to break apart the independent contractor relationship, try to impute liability upstream for subcontractors. So obviously Texas, being right-leaning, is trying to prevent that from happening, at least for state projects. Then there's been a big push in Texas, which is a unique outlier, that the contractor historically has borne liability for design errors and omissions, even if it's a traditional design bid build project. A lot of sort of nerdy case law kind of explaining how Texas is a minority jurisdiction in that regard. Most of the country, it's clear that the contractor isn't at fault for design errors, but Texas kind of has their case history through the idea of when contractors are kind of true artisans, and the idea being, well, the contractor probably knows as much about the design as the architects. This is before the architects kind of developed as a very niche sort of white collar industry, different from doctors or lawyers. But in any event, it's been a lot of legislation recently to help sort of pare that back on commercial projects, though certain lobbyist groups have carved out those protections for their specific industries, most notable being oil and gas. But at the same time, oil and gas or industrial projects typically are engineering, procurement, construction, delivery methods. So there's usually a design component if you're the contractor on those. So it's fair enough maybe for that portion of the construction industry not to be subject to the recent legislation.
Why do you think that is? Why do you think there's, because Texas is right-leaning, why are they taking a position where they don't, they're okay with that? They're okay with taking on that responsibility when it's clearly not in their control?
Yeah, it's the kind of the inside baseball of how case law works, which is judicial opinions. A judge issues an order, explains the rationale. That can provide the basis for future disputes to understand how you should decide the merits of a legal fight amongst the parties. And there's a notion of stare decisis, i.e., you give precedent to prior opinions so you can build up a series of opinions to kind of have a very established sort of rules of the road. So you're not just yo-yoing between two different sides depending on the day. And I think we see that sort of the federal level with do we have emissions? Do we not have emissions? It makes it very hard for any business to have a predictable set of rules to understand, how am I going to try to make money? How am I going to try to, hedge my bets and understand, what do I need to do to manage my business? Tariffs are a perfect example that's running, makes it so hard on companies, across the board, certainly construction, to, control their risk, control their potential losses. So the idea is in court system, you give deference to prior rulings to create sort of a consistent outcome. And as a result, it's hard to overturn a bad ruling. You have to really show that the whole premise is fundamentally flawed. So it's very rare that you see those cases. And so you can think about, in the national setting, sort of more of the social issues, where a federal Supreme Court ruling had held this, and then recently the Supreme Court justices have changed course, and so that causes a lot of consternation. So obviously, there's usually good reasons for why you change the position, but it's very hard to do. So you really need the legislature to kind of step in and.
I mean, why would Texas want builders that are not designers and that knowingly do not sign a design build contract to be held responsible for design flaws?
It's a good question, which is why it's been a big push in the industry for decades to try to dial back this early 1900s case precedent. It actually came out of San Antonio. It was called Lonergan is the name of the opinion. That again, it was the idea of the old industry is artisan, so that the builder was not just a contractor. They were a full shop. It wasn't.
They were master builders back then. They did everything, right?
Exactly.
But it's not at all that way today.
Exactly. So so the industry has pivoted away from the master builder concept. It's very specialized. The general contractor is basically a babysitter. and the actual trades, the skilled workers with specialized knowledge of how to construct a building, or the different subcontractors. But the case law just never really caught up with that. You have that interplay with the fact that the AIA is probably one of the strongest lobbyist groups in the country for construction. So the architects kind of written the rules to insulate themselves from a lot of liability, and it's been difficult for Texas. Again, it's a weird quirk within Texas of why it's taken so long for the legislature to kind of rewrite the rules to match just what the industry does on a day-to-day basis.
So in the interim, which we look for this, is you got to look for those clauses that talk about fit for intended use or purpose, or anything that's design related in those agreements, right?
Exactly. So if you default to the AIA series contracts, they have the provision, the A201, that says, in essence, a contractor reps and warrants that it's reviewed the project plans and specs. However, in short, if you see something, say something. So if you spot a clash, design conflict, you need to submit that RFI reasonably promptly, so that way the owner and architect can address it. And if you do that notice timely, then that kind of takes the design error off your liability sheet, pushes it on the owner and architect. So it's just about rewarding due diligence in construction, which that's kind of the watchword for most project management, is just making sure you're on top of your game. If you let things slide by, problems don't get better with age, they just get worse. So you need to have those hard conversations up front, because they're only going to get harder and more costly to resolve as the project progresses.
Timely notice. All the time.
All the time, in writing. You can be polite.
It's like you should prompt to, write an email every single day, put everything you can possibly put in it to notify them of everything that could possibly be going on that day, so that you're covered for everything.
All right, it's a sweet spot there, right? No notice is bad notice. Too much notice is unhelpful notice, because how do I actually know what the true problem is? So you need to be, what is that sweet spot? That's where you separate the good contractors, the good project managers, from the bad ones.
To me, that's really the key, is figuring out who you're working with. And, because at the end of the day, you keep the contract in the drawer, you can solve everything really quickly. And as long as everyone is fair and equitable with what's going on, and use common sense, everything can be worked out, and it can be fair across the board. And you win some, you lose some, you take the haircut on this one, you'll make it up on the next one. And as long as you have good partners and good, for us, good general contractors that we work with, that are happy to ebb and flow with you on risk and responsibility, then those are really easy conversations. Those are really easy partnerships. It's the ones, and I see this a lot with the newer PMs that are coming out of school that, I don't know, they're trying to make a name for themselves or what the issue is, but they feel like they have to win every single time. And almost view subcontractors like, they're a 4-letter word, and it's not a partnership mentality. And so we definitely try to avoid those, but there's a lot in these contracts. I mean, some are written really well. Some are very ornery, and some are really fair, but there's so much going on, I feel like, and there's so much risk in these projects. And, I used to work for general contractors, and, more and more I see the contracts pushing more and more risk down to the subs, while also beating them up on pricing. So it's more and more important to have, good attorneys like P&A inform subs, and I'm sure GCs too, but really the subs, because we carry the risk and we also are being asked to fund the job. I'm sure you're probably seeing that too, where payments are getting slower and slower and slower while we're being pushed to take on more and more risk. The design issue is just one of the many.
It's all about relationships, and I think that's a common trope in the construction industry. But it's certainly true that projects that can be challenging can be resolved if those lines of communication stay open. It's kind of when the chest beating happens between the GC's PM and the subcontractors PM or superintendent, that things can get off the rail. Then it becomes extremely adversarial. The lawyers get involved. There's a huge letter writing campaign. Everyone kind of entrenches their position, which doesn't serve anyone, because in litigation, 95% of cases that get filed are going to get settled short of a lawsuit. Even if you go the distance to trial, whether or not you can recover all of your fees is questionable. Even if you have a clear legal entitlement to recover your fees, the judge or jury, depending if it's a bench trial, i.e. trial only before the judge, or jury trial, if they're going to reward you everything that you asked for. So there's a huge sunk loss. And I think the contractors or subcontractors who've been through that process once or twice realize the juice isn't worth the squeeze. Fighting over principle and my lawyer is better than your lawyer is not the best business decision, but it requires companies that are seasoned in disputes to understand when they need to make that compromise. The issue is that it takes two to tango, and if you have an unruly owner or you have an unruly contractor, and certain contractors have a reputation for chewing out subs, it becomes hard to have that fair and equitable resolution. So it kind of goes back to, on the upfront end, what does that contract look like? You want to look at it, understand, how one-sided is this? That's where you'd love to get an attorney on it. You may not want to spend the money on the upfront when you're especially bidding on a project, but you're going to spend a heck of a lot more on the back end for a very unfair unfair contract with a tough contract counterpart. So that you may spend a couple $1,000 with the attorney for that detailed contract review to assist in negotiating some revisions to that contract, because you'll get a good sense. Is this a party that I can do business with, that I can negotiate with, or is it the other side, my way and the highway? And if that's the case, is this a project that you really want to do? Obviously, someone will take it, but that person may not be in business after a few years, because you can only absorb so many losses on bad jobs before the company starts to suffer financially.
Construction companies go out of business for the wrong jobs, not for not having enough work, right?
Exactly.
If you were to spitball, what's the average dispute size that you handle?
For me, since we generally are representing national, international general contractors, the amount in controversy is more often, over $1 million. I think most of my disputes are probably between $1 million and $20 million for sort of commercial projects. If you're dealing with large federal public works projects, right, it's monopoly money. It seems like at the end of the day, an $80 million claim seems like chump change, which is wild to me. It's just a general person to understand that is just a rounding error in the size of the total cost of the project. But we do a lot of work for subcontractors. Right? Those are smaller contracts, smaller disputes, so that only may be $200,000 to $600,000 type dispute, which is real money for a sub. Though if you went the distance to trial, you're going to potentially rack up as much in attorney's fees as you do for the amount in controversy. So that's where it can be a challenge to manage the dispute. And I think I enjoy those types of disputes because you're having to do a lot more with less. There's a lot of guidelines that the client's putting on you to be very cost efficient. So you have to be really diligent in how you think about a case, how you can work a case to get to the point where both sides are willing to sit down at the settlement table to try to hash out their differences and reach a resolution.
So a contract review is probably in a few thousands, right? Yeah. So it's definitely more cost effective to get that right on the front end and make sure you're evaluating who you're working for if you're a sub. I guess even for GCs, I mean, when I was working for a GC, one of the things we had to do anytime we were going to take on a project is get proof of funding so that we knew we weren't going to be the bank. And I think it's important to run through those contracts, and especially now with the way things are changing, and get a good attorney to help you review those things and try to keep that thing in the drawer, because when it comes out, it gets expensive. But
it does. You can never contract for every uncertainty on the project. There's always going to be something wrong. I thought I had an exclusion, and you look at it, I'm like, I could interpret that to mean something different, and now we're going to have a roll the dice on what the judge or jury, or if you're in arbitration, the arbitrator will interpret that contract to mean. But yeah, spending the money up front to review the contract, understand the risks, understand the notice provisions, or what's the change order procedures for this contract. Is there a pass-through provision if you're the subcontractor for claims that are due to the owner's acts or omissions? Now, all of that is helpful, because that's how you can manage a project. I know I got to be diligent on notice. I know that I have to be very buttoned up in project controls, so that when I submit change requests, it's not just a WAG attached to that change request form, but an actual vetted cost. So that way my change request is taken seriously. And then after you do a couple of contract reviews, your project team's going to really understand it. Like it's a lot of the same type form. So you'll be able to I know to look here, I know to look here, and you can kind of manage it in-house after a period of time. Obviously worth to have an attorney on hand just to spitball something, especially during the project. I'd much rather have a client call me up during the course of construction, like, hey, we got an issue. You have 30 minutes to just run this by you. Of course, because that way that doesn't become a major issue, and the client's calling me at the end of the project saying, like, I am out a whole ton of money. We need to sue because I'm hurting. I'd rather make the problem go away during the project if I can, so that way those clients are long-term relationships and they stick around. I think certain attorneys may view it a little more commercially on their part of, this is a revenue generating opportunity for me, and I'm going to maximize the revenue coming into my firm. But you're not going to have a long-standing relationship with that client. And getting back to construction being all about relationships, I'd rather build that trust and say, this is one you need to eat because it's not worth it. And then if there's another dispute where I think, hey, this is one we really need to double down on our position, that the client understands that the advice is coming to facilitate the client's business and not my own, personal financial interests.
Right. Well, I really appreciate that with P&A and you specifically, and Dennis. You guys have been great partners and helped us tremendously. But we have like 2 minutes left, and I have to ask you, being March Madness, you got a bracket? How's your bracket doing?
No bracket this year.
Oh,
I
no.
got a 7-year-old and 2-year-old boy at home. I have no opportunity to watch sports. It is all Paw Patrol and Nickelodeon. So I'll root for U of H, for, law school, adopted
They're still in it?
college. They're still in it, so we'll see if how far they can go.
So that's who you're going with? You pulling for them?
Go Cougs.
Okay. Right on. Well, I appreciate it. I appreciate you coming on and talking to us. And, I just want to reiterate to all my subcontractor friends out there to get some good sound legal advice, and highly recommend you guys over at P&A.
Enjoy the recommendation, but yeah, certainly it's better to get sophisticated lawyers and know this. The construction bar is a very tight-knit community within Texas. I have a lot of attorneys I work with all the time that, again, talking about relationships, that you're managing your relationships, between sub and GC, and I'm managing my relationships with people, that may be adverse to me in law firms. But if I can work together with that lawyer, that helps the clients work together and get that dispute resolved.
Yes, sir. Well, thank you very much. Good to see you.
Appreciate
the
Joe.
input. Yeah. We'll talk to you soon.
Sounds good.
All right.
Take care.
See you, Lee.